So what specific documents and evidence do you really need to collect, and how do you organize and present them correctly so a judge will understand, especially since you don't have a lawyer? I'm Renee. I'm a certified domestic violence advocate, a divorce mediator, parent coordinator, and the founder of the Custody Blueprint program. A lot of times people are feeling overwhelmed by documentation. Maybe you have a mountain of evidence and you don't know what to do with it. And you fear procedural missteps, things that will make you look bad in court, maybe make the judge not like you in court, which of course is what you're trying to make sure doesn't happen. There are three big things you need to keep in mind when you're choosing the documentation to actually bring in. First, you really want to start with everything that can be on paper. For example, you can print out emails and text messages between you and your ex. You can print out emails from teachers, coaches, doctors, and so on. You also can print out transcripts from audio recordings, video recordings, if these things are legal in your state or province. You do want to walk in with an actual transcript of it with timestamps marked for where you think things are relevant. Second is you want to prepare your witnesses. It is so important and so crucial that you have third-party witnesses. Even with evidence, it can start to feel a little bit like it's just your story. If you have witnesses who are neighbors, doctors, coaches, therapists, tutors, and so on, those are the people you want to start with. If your family or friends have witnessed something particularly egregious and they have documentation of that, that could be very good too. The third thing to keep in mind is that you're really looking to present things that are admissible, relevant, compelling, and streamlined. They're admissible, meaning that you are allowed to submit them in court, and you want to do a little bit of research on that. Relevant. It's easy to bring up things that happened in your relationship with them in the past. Some of that may be relevant, but the truth is you're really looking for stuff that is directly affecting the children. Compelling. If you have a mountain of evidence, if you have 100 pieces of evidence, what are the 5 top pieces that you know are going to move the needle in court? So really narrow it down to be about 5, maybe 10% of what you've got. And then streamlined. That's where that comes in. Narrow it down. Level up your case. Pro Se Clinic for self-represented parents. More info at proseclinic.net and below. Your truth, your evidence, your victory.